you also. Then I guess I'm going to start right away with the introduction. Thank you very much. Dear ladies and gentlemen, it is both a great honor and joy to introduce our dear Professor Nikolaos Davrados to you, who is now a professor of law at the Louisiana State University, the Paul M. Hebert Law Center. Professor Davrados has achieved his PhD in law and then his bachelor, of course, at the University of Athens School of Law, and his master at the University of Oxford. His main scientific interests include civil law obligations. We will enjoy that during today's lecture. Also, he also deals very much with matters of the general principles of civil law, sales and leases, conflict of laws, also matters of international business transactions and immigration law. And he has to show a great palmarès of publications already, a very considerable wealth. So with no further ado, I'd like to introduce our dear Professor Davrados to you, and dear ladies and gentlemen, please enjoy.
Well, thank you for that very generous introduction, dear Dimitri. Thank you for having me. I'm going to share my screen if that's okay. Let me see how I can do this. Okay, I need to for the host to enable me to do that.
I think you can directly do that by sharing your screen.
Oh, it's ready. Thank you, Andrea. Mm-hmm. Okay, let me do that. Okay. Okay, does that work? Wonderful. Okay. So again, thank you so very much for having me. It's indeed an honor and a privilege to be here with you to talk to you about unjust enrichment. Before I start with this complicated topic for a Thursday evening for all of us, let me just start with two apologies. Let me just make things clear. Two apologies are owed. First, I am a professor of comparative law, which means that I profess to be an expert in civil and in common law, when in fact I'm not an expert in either. So please forgive me for my mistakes, my inaccuracies, my shortcomings, and my ignorance as I address your own national legal system. I'm sure I will not do a good job at it. That's why I invite your comments in the Q&A. So I'll try to keep my presentation as brief as possible to enable our discussion and our exchange of views. So that's one apology that I owe you. The second one is that it's impossible to present unjust enrichment in 1 hour. So this will be a very general presentation. And so my second apology is apologies for not including everything, for being maybe conclusory, for being overly simplified in general. Certainly there are intricate details, especially from your own legal systems. And again, I invite your discussion in these matters. Now, furthermore, the topic of quasi-contract, that terminology is mainly found in French law. I know from those of you who are from German or Greek legal systems, you may not be familiar with that term. Or maybe you are, but in Germany and in Greece, that term does not appear in modern civil law systems based on the German model. But based on the French model, we do encounter that term. So I will be referring to that term generically for all civil law systems when I refer to negotiarum gestio, of course, the management of affairs of another person, and unjust enrichment. So having set the general scene, and again, please bear with me and thank you for forgiving me for my mistakes, I will move on to our basic thesis, our basic question, which is the following. We all know what a contract is. We all know that if I agree to sell you something, I am bound to you under the terms of that contract, and the obligations that are created are contractual in nature, our juridical act, our act juridique, our Rechtsgeschäft. That basically will deal with our transaction, which is voluntary. So that's pretty much what happens with the field of contract law. Now, if I hit your car with my car, that would be a tort. That would be an accident. That would be a delict. That would be something that generates an obligation to pay you compensation under the law. So the two poles of the law of obligations are pretty much set. We have contract, we have tort, but then there's an area in the middle. We all identify that area. We all understand that that area exists between contract and tort, and we've come up with different names for that area. Here we have obligations that are raised by law. They're not a product of our agreement, but they're also not torts. I have not done anything against the law to damage you. But there is some sort of juridical act or juridical fact that occurred. There has been an obligation that has been created. That source of obligation is not a contract. It's also not a tort. It's somewhere in the middle. How do we call that? Well, we have different names according to where you're coming from. For our friends who come to us from common law jurisdictions, the name that you've come up with is unjust enrichment, generically speaking. If you look at the third restatement of restitution and unjust enrichment in the United States, you will see there that the term unjust enrichment is used as a substantive term, and the remedy for unjust enrichment would be restitution. If you look at the wonderful work that's been done by our English colleagues in Australia, you will see there, especially after the work of my own professor, Peter Birks, we have a good legacy there of unjust enrichment law and the common law, which has spread and is pretty much acceptable, an accepted term of art, unjust enrichment in the broader sense of the term. If you're coming to us from France or from legal systems based on the French law, such as my legal system here in Louisiana or Quebec or other legal systems on the continent, we still use the term quasi-contract. It still appears in the French Civil Code after the revision of 2016, even though it's a very criticized term. Louisiana and Quebec have abandoned the term. Germany and Greece and other legal systems have long abandoned the term since the time of Savigny, but we're still familiar with that term that basically means something between contract and tort. And this distinction exists. We all know about it, but it's very imprecise. We have tried to define it. We have tried very systematically, because we like putting things in boxes, to categorize it. But this middle category defies categorization, one would say. That is why Gaius, back in the day, the Roman jurisconsult, basically said, you have contractus, you have delictus, and you have varis causarum figurae, things just in the middle, right? And then by the time of Justinian, we had contract, we had delict, and then we had quasi-contract, quasi-delict, somewhere there in the middle. And that's where the confusion started, when we tried to interpret and understand what these terms mean. So that's the basic idea. That's what I want to discuss with you tonight. I hope you find it useful and helpful, just to keep you busy on your Thursday evening. Here's our roadmap. I'm going to start off with a little history lesson for myself. Of course, you're well aware of these issues. I'm going to try to explain to you and convince you that what we have today called quasi-contract is very complicated, and indeed it's based on a wrong doctrine. The traditional doctrine on quasi-contract is plainly incorrect. And this is due to misunderstandings of Roman law and Greek law that came up until the time of the post-glossators, and especially after that time, Domas, Savigny, to whom we owe our modern civil codes, simply misunderstood this term. They tried to categorize something that maybe defies categorization. So we're going to spend a few minutes talking about that. And after we've laid the historical foundation, we're going to fast forward to today and look at a comparative, a very broad, as I mentioned, comparative excursus, a comparative presentation of quasi-contract in the civil law and in the common law. And as you know already, quasi-contract is interesting because there's no clear divide between civil and common. As we will see, German law looks very much like common law, and then French law follows its own path. And so it's an interesting concept that kind of permeates the civil common divide. It kind of defies the civil common divide. And I'd be very happy to hear your thoughts on my observation as to how quasi-contract simply is mixed up, right? All over the place. And so with our roadmap in mind, let's get right to it. Let's start with a little bit of history. So we're back in Roman law. The Romans, as we all know, were very practical oriented. There was no such thing as Roman doctrine back then. I think we come up with that later when we rediscover the Roman law. The Romans were very practical. They had their formula. They wanted to find what formula applied, what instructions would be given to the iudex for the iudex to give justice, to give a judgment that would be fair. And so we had our jurisconsults back then who basically gave these practical instructions. One of these very famous jurisconsults, as we know, was Gaius. And so in his institutes, he explained what an obligation is, which we all know what that is. It's a legal relationship between two parties, the creditor and the debtor. I owe you $10. I am the debtor. You are the creditor. I have to perform. That is the basic concept of an obligation, of a Schuld, as we would say in Germany. And so Gaius started explaining where these obligations can come from. And so he gave us a distinction that still exists until today. You can have an obligation that is voluntary, a contract, or you can have an obligation that's involuntary, a tort. And so back to my example, I owe you $10. Why would I owe you $10? I could owe you $10 because I agreed to owe you $10. Perhaps I purchased a book valued at $10 and I owe you that amount. Or perhaps I could owe you that amount because I borrowed the money from you. Alternatively, we could have a tort. I owe you 10 euros because I caused damage. I hit your bicycle, I damaged it, and now I owe you 10 euros in damages. So it's clear that we have voluntary acts on one hand, juridical acts, acte juridique, Rechtsgeschäft. And then we have what the French call fait juridique, right? Where we have an unlawful event, a civil wrong, a tort on the other end of the spectrum. So Gaius pretty much established that distinction, which follows up until today. It's a wonderful distinction. And those of us who teach civil law are based on that distinction. But Gaius quickly identified that middle area. Remember that gray area between contract and tort. And he gave us a few examples. He gave us the example of a mistaken payment. Let's suppose I pay you 10 euros by mistake. Now, you receive the 10 euros. There's no contract between us justifying you to keep that 10 euros. You didn't trick me into giving you the 10 euros. There's no fraud involved. So this is clearly not a tort either, but nevertheless, the law obligates you to make restitution, to return the 10 euros to me because they are a payment that is not due, a conditio indebiti, as Gaius said. So that's an example of a situation where there's no contract, there's no tort, but still you owe me 10 euros. He mentioned other examples. He mentioned the example of a co-ownership. Let's suppose that our great-grandfather passes away and we inherit his land. You and I are co-owners of that land. Based on that fact of co-ownership, which we did not agree to, the law simply imposed it on us, we have certain obligations to each other. These obligations stem from a juridical fact that is neither a contract nor a tort. Another example that Gaius mentioned was the example of tutorship of a minor. If the court appoints me to tutor a minor, I have certain obligations toward the minor. She is under my care. And these obligations are created neither by contract nor by tort. And so these are examples of situations that fall kind of in the middle. And Gaius didn't put a specific label on them. He just called it miscellaneous. So we have contract, we have tort, and then we have miscellaneous. And then later on, and it's questionable whether Gaius wrote this, this particular excerpt from the digest. Some think that it was added later during the time of Justinian. Gaius elaborated further on this middle ground. He said, okay, we have this middle situation. Some of these middle situations, like the mistaken payment I explained to you, they look more like contracts. So I'm going to call them quasi ex contractu. Now, Gaius was careful to tell us that, look, these are not contracts. These are not first cousins to contracts. They simply have effects that resemble a contract. And then he named other acts of negligence, because back then tort was only intentional, as a quasi-delict, which later on joined tort law. There's no problem with quasi-delict. But with quasi ex contractu, Gaius was quite clear that this is just a generic label. It has no doctrinal meaning. It was just a practical explanation of certain miscellaneous quasi-contracts like unjust enrichment and mistaken payments. So we fast forward several centuries. We're in the 10th, 11th century AD. The Roman laws and Greek laws were rediscovered by civil law scholars in Italy, France, Germany, and the continent. They rediscovered the digest. The digest became in fashion. The Roman law was revived in Europe in the medieval ages. And so the glossators, Bartolus, Baldus, these great glossators, revisited the scriptures, revisited Gaius, and they misunderstood Gaius. That's the first misstep. So they understood quasi ex contractu to mean ex quasi contractu. In other words, they created an independent source of obligations. They created a doctrine out of just a practical label. And so suddenly, negotiorum gestio bundled with unjust enrichment, which were examples back in Gaius's time of quasi ex contractu, miscellaneous obligations that had nothing in common, right? Suddenly now we have this new category. We have this independent source of obligations that exist as if there were a contract. So back to the example of a mistaken payment. I paid you $10 by mistake. You now owe me the repayment of the money as if you borrowed the money. Do we see the difference? So the judge here is supposing that there's a loan. The judge is creating a loan even though we never agreed to a loan. If I manage your affairs while you're absent, for example, you're away on vacation, a storm hits, it damages your house, I am your good neighbor, I repair your house. I would be entitled to reimbursement perhaps under the law of negotiorum gestio. Under the glossators, that would be a quasi-mandate. It's as if I am your mandatory, an agency, which is not what the Romans intended. And so basically, our whole foundation of the modern law of negotiorum gestio and unjust enrichment is based on a mistranslation. This is one of the most, in my opinion, egregious mistranslations and mistakes of the digest, at least in the civil law. So based on this misunderstanding, we've inherited a bad law, I would say, a messy law, a law that defies categorization because it never was intended to be an independent category. But that was the first medieval misstep, as I call it. And it continues. Based on this mistranslation, the glosstators and later on the civil law doctors came up with a doctrine of quasi-contract. Okay, we have an independent source of obligations called quasi-contract. Let's find a doctrine for it. What is the legal basis for this obligation? Why do you owe me 10 euros if I paid you 10 euros by mistake? Well, one thing that happened, and I explained it earlier, is we're going to make up a contract. We're going to assume that we had a contract even though we didn't. So that's where the name quasi-contract came from, sort of like a contract. And at common law, you might be familiar with the term implied contracts or constructive trusts and contracts. These were all created by this misunderstanding of the Roman law. So the fictitious contract theory was one explanation, joining negotiorum gestio and unjust enrichment under one umbrella of quasi-contract, right? Restitution must be made on the basis of this fake implied contract. Now, of course, we all know that there is no contract. We know that the judge is creating a contract. And so why resort to a fiction is the question. Legal fiction certainly is important in certain areas of the law, but what is the necessity for a legal fiction here? What are we accomplishing by a fake implied contract? Scholars quickly criticize this theory as formalistic and quite deceptive. Can a contract ever be implied in law? Maybe you can imply a mandate for negotiorum gestio. Maybe you can imply a loan if you have a mistaken payment. But what if you have other types of unjust enrichment? For example, mistaken improvements on your property. We're neighbors. I build an improvement on my property, a beautiful garden, but by mistake, I crossed over onto your side and I've made improvements on your land by mistake. Would you owe me restitution for that? Perhaps yes, perhaps no. We can discuss that. But can we have a fictitious contract there of any sort? And so we see that the fictitious contract theory is a legal fiction of limited applicability and limited usefulness, and it's very questionable as well. So that theory was quickly dismissed, even though, even until today, our friends at common law used implied contracts all the time as a term. And in the civil law, especially in the French legal tradition, we're still stuck with that quasi-contrat, the quasi-contract in the French law. And then we have a second explanation, which is based on Potier's work, the theory of equity. Basically, what this means is that restitution for quasi-contract should be awarded because it's fair, because equity so demands. Well, who can disagree with that? The law needs to be fair. Equity needs to be observed. Now, when I say equity here, I'm referring to the Roman equitas. I'm not referring to the common law equity of the chancery courts. Just a word of caution there. The question, however, is this a precise, manageable theory, or is it just a general statement of the law? I submit to you that equity permeates the entire law. If I promise to pay you $10 under a contract and I don't pay you, that's unfair, isn't it? So equity is the basis for breach of contract, correct? If I hit your car and the damage is 100 euros, I have to pay you, otherwise it would be inequitable, wouldn't it? So tort is based on equity. If my great-grandfather dies intestate and my father precedes me in the succession, my father needs to inherit before I do because he's more closely related to him. So the law of succession is also based on equity. Criminal law is based on equity. Everything is based on equity. So equity simply is too broad and vague a statement to turn this into a manageable theory. So what we've observed so far is that quasi-contract was never meant to be a doctrine back in Roman law. The glosstators, 1,000 years later, turned it into a doctrine, and the explanations they gave are far from convincing. I hope I've convinced you of this, even though I'm very open to discussion. So what do we have? What have we inherited? A false doctrine. And what do we do with that today? Well, we're going to talk about today's law. Before we do, let's just talk a little bit more about history. Fast forward a couple of centuries. So the French-German divide. So Savigny took these theories and he quickly dismissed them. And that's why in the German law, you no longer have quasi-contract, or in Greek law. You have Rechtsgeschäft as a source of obligations, and then you have the law. So obligations can come from contracts, basically, or the law. And the law could be unlawful acts, which could be tort, or lawful acts that give rise to damages. What the French would call faits juridiques, licites ou illicites, juridical facts that are licit or illicit. That's the German scene. And that's why, for those of you who were trained in Germany or in Greece or other jurisdictions based on Germany, maybe quasi-contract is not a familiar term. But for our friends who join us from the French legal system and its satellites, Quasi-contract is certainly a term because it was retained in the Code Napoleon in 1804. Domas and Potier's equity theory seeped into the French Civil Code, and the term quasi-contrat was used. It's still used today, even though it has been heavily criticized. Nevertheless, it survived the 2016 revision, and it's there. And basically, it means negotiorum gestio and unjust enrichment. Now, if we have enough time, we can talk about this later. French courts are coming up with new types of quasi-contracts. The example would be the announcement of gains from a lottery would, according to some in France, amount to a quasi-contract. That might be questionable. Nevertheless, France is still holding on to this concept, even though most French scholars agree that this is a false concept. Nevertheless, what is true is that we do have two institutions that we call quasi-contract, inaccurately maybe, but they do exist: negotiorum gestio and unjust enrichment. And what I will do now is focus my attention on both of them under a redefined understanding of quasi-contract. Quasi-contract, at best, if we're still using it, should be demoted down to a descriptive term. We need to go back to Gaius, all the way back there, and start over. And we need to understand that this is a practical term, and it basically means unjust enrichment and negotiorum gestio in the civil law. As I will explain later, these two concepts are kept separate in the civil law. At common law, there's kind of a blend between negotiorum gestio and unjust enrichment. If we have time, we can discuss that as well. But clearly in the civil law, there is a divide between the two. And so quasi-contract must be demoted down to a descriptive concept if we're still using it. And I'm speaking to our friends from France, Quebec, Louisiana, other jurisdictions based on the French model. Furthermore, if we want a rational or legal basis for our redefined quasi-contract, what has been proposed, and we have to keep it as a general explanation, is that quasi-contract basically means restitution for a benefit received without legal justification. Unjust enrichment in its broadest sense, as our friends at common law would say. And I think that's accurate. If you think of the example of negotiorum gestio, here's the example again. You're away on a holiday, a storm hits your house, I'm your neighbor, I repair your house. That could fall under negotiorum gestio. If I made certain expenses to repair your house, I may be owed a reimbursement from you. You've received a benefit by the repairs that you didn't pay for. There is no legal justification for the benefit you received. There was no contract between us. There was no law obligating me to be a good neighbor. I did it voluntarily. And so now you have to make restitution. You have to give me reimbursement for that benefit. So that might work as an explanation. Likewise, if I pay you 10 euros by mistake, you would owe me restitution of that money because you have no just cause for retaining that money. There was no contract entitling you to keep that money. There was no law giving you the right to hold on to that money. And so now you need to make restitution based on this quasi-contractual, air quotes, quasi-contractual obligation. And so generally speaking, one could say that quasi-contract, if we're still holding on to this term as a descriptive term, is basically the obligation to make restitution for a benefit that you received without being entitled to it. I think that could be a workable, practical definition for our discussion following. Now, turning our attention to more specifics to negotiorum gestio and unjust enrichment, here's the example again: urgent repairs to your home is an example, right? An example that goes back to Gaius. He uses that example in the digest. Another example would be emergency medical services. For example, someone's walking down the street, she passes out, she faints, you're in the area, you rush and you give this person emergency medical assistance, and you spend certain money to do this. For example, perhaps you're a physician. You would be entitled to some reimbursement under the law of negotiorum gestio. Finding lost property and returning it, rescuing other property. An example would be maritime salvage, marine salvage. A vessel is in distress, they call out for help, an adjoining vessel comes to the rescue. Rescuing the vessel would be the basis of marine salvage, maritime salvage, and that basis goes back to negotiorum gestio. So we're familiar with negotiorum gestio. We're familiar with being a good neighbor. We have negotiorum gestio well settled in the civil law. But as I noted, quasi-contract kind of transgresses, it doesn't obey the civil common divide. For example, there's a sharp distinction between the French model of negotiorum gestio and the German model. And it goes back to Domas and Potier in France and Savigny and Puchta and Winscheid in Germany. So the French model goes all the way back to the misunderstood quasi-contract concept, is a quasi-mandate, the fictitious contract theory, remember? So the French understand negotiorum gestio as a type of unofficial agency, unofficial mandate, as if I had a mandate with you to repair your house or to rescue your sailboat if your sailboat ran astray. Now, this has certain implications that are very important. First of all, under French law, the manager must have contractual capacity to be a negotiorum gestor. So if I'm a minor, or if I'm intoxicated, or if I'm interdicted, if I have no legal capacity, I cannot be a negotiorum gestor. This whole relationship would be based on unjust enrichment. That might be a questionable result because it makes negotiorum gestio look too much like contract. But that is the prevailing opinion in France as of today as well. Furthermore, a step forward, making the French law much broader, the manager can bind the owner toward third parties. Because I am basically your quasi-mandatory, your agent, I can make contracts with third parties. Here's an example. I repair your house. To repair your house, I purchase certain building materials on credit. I go to a store and I buy something and I don't pay for them. They're on credit. The store owner can sue you, the owner, the principal of the affair, for repayment. Why? Because my contract with the store owner binds you. And so a triangular relationship can be contemplated in a French type negotiorum gestio relationship. Conversely, the German model of negotiorum gestio is much more restricted. The Germans placed negotiorum gestio right after mandate, and they did that to disassociate it from mandate. It's clear that we're having here a management without mandate, which could either be genuine when I'm managing your affair, knowing that I'm managing your affair and it's a foreign affair. I repair your house. I know that it's not my house, and I do it to help you. That would be a genuine management of affairs under German law. And then there's the false management of affairs, when I basically commit a tort. I think it's my own affair, and knowing that it's yours, I try to take property away from you, or I interfere in your affairs without being invited. I am what the common law folks would call an officious intermeddler. That would be a false management of affairs when I'm a bad actor. So Germany basically distinguishes the two and restricts negotiorum gestio clearly to the case of a genuine negotiorum gestio, which would also apply in French law if we go over the requirements there. But still, the German model is restricted in this way. The manager does not have authority to bind the principal. So any expenses I make are still on me. The store owner for the building materials cannot sue you. I am still liable for those, and you might owe me that money as reimbursement. But clearly, I am not your agent. I am not your mandatory. I am not binding you toward third parties. And we see that the German model is removed from the fictitious contract theory. The Germans actually disavow any type of contractual nature of the negotiarum gestio. That is why capacity is generally not required for the gestor, at least with respect to their right to reimbursement. And so clearly here we have a divide within the civil law. And then we have our friends at common law. Now, several comparativists will tell you that negotiarum gestio does not exist at common law. You can't be a busybody. You can't be an officious intermeddler. If you do, we're going to call you names. You will be an official intermeddler. So it's not allowed. That's not entirely accurate. If you look closer, the common law, even though they don't use the term negotiarum gestio, they do allow restitution for emergency services. I'm giving you here the example of the third restatement of restitution and unjust enrichment in the United States. It was enacted in 2011. It's a wonderful restatement that kind of brings order into chaos, at least for US law. And there, if you look closely at sections 20 and 21, you will see that restitution is allowed for emergency services. The example again, providing emergency medical aid, or providing emergency repairs to property, or rescuing property from imminent harm or danger. The rescuer would be entitled to restitution for their reasonable expenses, and sometimes they might be entitled to a fee for their services, which is also gaining momentum in the civil law as well. So the example of the physician that I mentioned earlier, who provides emergency medical services, that physician might be entitled to a fee for their emergency intervention, even though it was uninvited, but it was necessary under the circumstances. And so what do we observe? France is still somewhat faithful to this implied contract theory when it connects negotiarum gestio with mandate. It's still wedded to the idea that we have a fictitious contract, and that's why mandate spills over into negotiarum gestio, especially with regard to the ability of the manager to bind the owner toward third parties. Then we have a very restricted notion of negotiarum gestio in German law. And then the common law, without saying so, does acknowledge negotiarum gestio as a reason, as a substantive basis for restitution. And as I will mention later during our discussion, the common law actually bundles negotiarum gestio together with unjust enrichment, something that does not happen in the civil law. We're going to talk about that as well. Now, let's turn to unjust enrichment. And to do this, we need to go another stroll in history, discuss a little bit the foundation of cause, the concept of causa, cause in comparative law. When we talk about cause, we're basically talking about the reason why I'm obligated to you. The French and the Germans understand causa differently. It's a Roman concept, but it's understood differently in France and differently in Germany. And by the way, common law is very close to German law. So again, here an example of a split between France and Germany together with the common law. In France, our friends from France might, or from other French jurisdictions based on French law, might confirm this. Juridical acts are causal in nature. There must always be a cause. Now, cause was removed from the 2016 revision of the French Civil Code, but I think the idea of cause is still in there. So juridical acts are basically causal. Conveyances are causal. So for example, if I sell you my bicycle, the act of conveyance has the sale as its cause. My promise to sell you the bicycle is the cause for the conveyance, right? So we're talking about a very broad notion of cause. If this cause fails, if the contract of sale is invalid, or if I breach it, then the law of cause and nullity gives you the right of restitution, right? So I sell you my bicycle. I deliver the bicycle. The sale is invalid. Suppose there's a vice of consent. Suppose the sale is illegal. It was made under duress, for example, another vice of consent, right? Or there's a breach and you sue for dissolution. The law of nullity and dissolution talks about restitution. So restitution happens naturally within the sphere of cause. And this goes back to Domas. The French jurisconsult Domas gave a rather broad definition of cause. He said that all juridical acts are causal, and the law of cause takes care of restitution. If a contract is void or null for any reason, then money is returned, restitution is made directly by the law of cause. So we don't need unjust enrichment as a specific heading. So what we notice is that restitution outside cause is unjust enrichment. So we need something outside contract law to have unjust enrichment in French law. For example, I provide services to you without a contract. We thought we had a contract, but there is no contract whatsoever. And now you have a value, something valuable from me. I repaired something for you. I gave you a service without a valid contract at all. A contract was never made. In that case, cause would not cover us. We would go to unjust enrichment. So what I want you to notice here is that in French law, unjust enrichment is very restricted because cause takes care of everything. And this goes back to Domas. This is not the same in Germany. Thanks to Savigny, we have a more systematic elaboration of unjust enrichment, and unjust enrichment permeates most of the civil law. The example should be familiar to our friends from Germany, Greece, and other jurisdictions. I sell you a bicycle. So we have the juridical act of the promise, the sale, and the juridical act of the conveyance, right? Let's suppose that the sale is invalid for some reason. What will happen? The sale, the transaction stands. So you still keep the bicycle unless it's an illegal object or an illegal agreement, in which case you will return it. But as a rule, the real juridical act is abstract. So you can have abstract juridical acts in Germany. But that's unfair, isn't it? You shouldn't keep the bicycle because the sale was invalid. What do we do there? Well, there, unjust enrichment comes into play. I cannot sue you based on the contract, based on cause, but I can sue you for unjust enrichment to make restitution. Whereas in France, if the sale was invalid, you would automatically make restitution under the law of cause. Whereas in Germany, we're adding unjust enrichment for the restitution, especially for abstract juridical acts. So cause is a more narrow notion in Germany, and restitution is accomplished through unjust enrichment more so than in France. Why is this? Because Savigny came up with the condictio and elaborated further on the condictio generalis, which applies with regard to unjust enrichment, and it corrects any restitutions that need to be made. Whereas in France, we still refer to cause to make that restitution happen. And so what we notice is two different models of restitution, two different models of unjust enrichment across France and Germany. And interestingly, the same applies at common law. Indeed, if I sell you something in the United States or in England or in Australia, under the common law, we have two transactions going on. We have the promise of the sale and we have the conveyance. The conveyance is made abstractly, independently of the sale. If the sale fails, then you need to make restitution of the conveyance. Precisely the principle of abstraction, the Abstraktionsprinzip that we got from Savigny, appears in the common law as well. So an interesting thing to note for unjust enrichment is the divided models within the civil law. So in France, you have a divided model. You have causa taking care of most restitutions. And if you're outside the spectrum of causa, then you can go to unjust enrichment. You go to the condictio indebiti for failed payment, for mistaken payments, excuse me. The example where I pay you 10 euros without a contract, there a condictio indebiti would lie. a payment of a thing not due, paiement de l'indu, and you would have to return that thing to the payor, to the solvents. And residually, there's the actio de renverso, the action for unjustified enrichment, unjust enrichment, where there you have a situation where it's not a mistaken payment, perhaps it's services that were rendered absent any contract, or improvements made on your property, or expenses avoided without the existence of a contract, in which case you would need to make restitution. And there are certain requirements under French law for this to happen. There needs to be an enrichment. There needs to be a corresponding impoverishment. There needs to be a causal link between the enrichment and the impoverishment, a lack of cause for retaining the enrichment, and importantly, the principle of subsidiarity. The action, the actio de renverso, only exists if there is no other action by contract or by law. So it's clearly a very narrow and restricted term. Actually, this never existed in the French Civil Code. It came up, it was created by jurisprudence. The Boudier case back in 1892, if I'm not mistaken, created the actio de renverso as an instrument of equity, and it made its way into the French Civil Code as recently as 2016. And so unjust enrichment is a very narrow concept in France because cause basically does the job. Conversely, our German and common law friends enjoy the unitary model. They have a conditio generalis, which takes care of everything, or so they think. That's also mistaken. Maybe Savigny gave us the idea of conditio generalis, but our German and Greek friends can confirm to us that that was a failed experiment. If you look at the German Civil Code or the Greek Civil Code or other civil codes based on German or the BGB, you will see several subsets of unjust enrichments. So they're kind of dividing it too. You have, for example, the conditio indebiti, the conditio sine causa, the conditio causa non secuta, causa data, causa non secuta, and other types of unjust enrichment bundled into one. But the fact still remains that unjust enrichment is used to make most restitutions. The example again would be a failed contract. Restitution is made through that failed contract. And of course, restitution is made absent any contract. So what we note carefully in this divided model is that the French follow a divided approach, which can be seen here in this Venn diagram that I have crafted for you. And it should be complicated because it is. So we see that if you have a failed contract or a tort, cause will take care of that. And then payment of thing not due is kind of in the middle because you can restore performances by suing based on contract or on conditio debiti. Here's an example. We have a sale. I sell you a book for 10 euros. The sale fails. Suppose I breach the contract. The book is not appropriate. It's not the book that you ordered, and you're going to sue me for breach of contract. You have two avenues to pursue. You can sue me for the breach of contract, and the law of breach will talk about the restitution, or you can sue me only for the money back. And that would be a conditio indebiti because the contract failed. There is no cause for you to hold the money, and you can sue me for the conditio indebiti for a failed contract to restore the performance. If you have a mistaken payment, you will see that that's outside the combination of the circles there. Mistaken payments are entirely within the premise of the conditio indebiti. So I paid you 100 euros by mistake. There was no contract or no law ordering the payment. I am entitled to restitution, and I will sue you under conditio indebiti, under paiement de l'indu, payment of a thing not due. And then you have the actio de renverso, which is outside the scope of cause, outside the scope of the conditio indebiti, even though theoretically the conditio indebiti is a subset of unjust enrichment. But nevertheless, in France, you have a separate action of enrichissement injustifié, an unjustified enrichment, where you can sue under that heading of the actio deum rem verso if the 5 requirements, again, are met: enrichment, impoverishment, causal link, lack of cause, and absence of another remedy. So the subsidiary. And then negotiorum gestio belongs in its own world. It is a fictitious mandate which gives rise to reimbursement, and it also binds the principal to the acts of the gestor. So that would be the divided model of unjust enrichment, which occurs in France and Quebec, in Louisiana, and other jurisdictions in Europe based on the French model, for example, Belgium, and I'd be interested to hear about your jurisdictions as well. And here's your unitary model of unjust enrichment. Looks like a solar system, doesn't it? You have your sun in the middle, your star in the middle, unjustified enrichment, and many planets orbiting this idea. Mistaken payments, the conditio indebiti, failed contracts, conditio causa data causa non secuta, restitutions for wrongs, obturpem causam, conditio obturpem causam, which there's a big discussion going on about disgorgement of profits. I don't know if we have time to talk about that. I'd be happy to discuss that if we have time. And then there's Pluto. There's negotiorum gestia out there. Is that a planet or not? Does it belong in the solar system of unjustified enrichment? That's a very interesting question. Our friends from common law would say yes, why not? In the civil law, that's not quite clear. In the civil law, negotiorum gestio is not a case of unjust enrichment. Let's remember that. And here's an example going back to Gaius. I repair your house. You're away on a holiday and I repair your house. The repair costs 100 euros. So you need to pay me 100 euros. 1 week later, the house is accidentally destroyed in a fire. Do you still owe me the 100 euros? The answer is, of course, yes, you do. You still owe me the 100 euros because that was an action under negotiorum gestio, even though your enrichment did not follow. If negotiorum gestio were a case of unjust enrichment, you would not owe me the $100 because the enrichment did not survive. And so clearly negotiorum gestio looked like unjust enrichment. They're first cousins, but they're not the same. So let's keep that in mind. Let's keep those two concepts separately in the civil law. Quasi-contract, as I mentioned, is at best a descriptive term, at least for our French friends out there. And importantly, if you look at the revised French law, and I know that Germany is moving in that direction too, we have a new remedy, a remedy of restitution. There's a chapter in the revised French Civil Code titled Restitutions, where there you group the various ways in which restitution is made. So there's an interesting shift going on in the civil law from substance to procedure. On the other hand, for our friends at common law, negotiorum gestio exists, even though you say it doesn't. It's there. You identify it as a case of unjust enrichment. That might be questionable, but still, you're acknowledging it. So if you look at the restatement third of restitution, there you will see emergency services bundled into the idea of restitution for unjust enrichment, even though in the civil law, those two institutions are quite separate. Quasi-contract was never an accepted term at common law, even though it has tormented our friends at common law as well, with the idea of implied and constructive contracts. And interestingly, in England and in the United States, especially after the third restatement in the United States, there's a shift. Quasi-contract, implied contract, was a remedy. And now they're looking for a substantive basis for that remedy, and the idea of unjust enrichment is being formed. Professor Birks, the late Professor Birks, basically enunciated this theory of unjust enrichment as the legal basis for restitution. I think this is a correct idea. I think that the restitution, the restatement in the United States also follows this approach. And so we're seeing a shift from the common law from procedure to substance. So it's interesting to see the two great systems moving at a cross-section in the law of what is called quasi-contract or unjust enrichment, broadly speaking. I see that I'm running out of time. Here are some issues that I'm not touching on today, even though I'm glad to discuss. First of all, my favorite subject, conflict of laws. Big discussion. What court has jurisdiction for a case of unjust enrichment? There's not a lot out there. I believe that the European Court of Justice is still relying on the decision in Calfelis years ago, decades ago. And it basically defined quasi-contract negatively. It said that unjust enrichment is something that's not a contract or a tort. Okay, that's correct, rather general. And then you have choice of law. I know that the Rome II regulation on the law applicable to extra-contractual obligations on the continent in Europe talks about unjust enrichment, negotiorum gestio, and also pre-contractual liability. It talks about the applicable law there. In the United States, there's the second restatement of the conflict of laws that kind of deals with restitution. We're waiting on a third restatement now, and we're eagerly waiting to see what will happen there. A third restatement for the conflict of laws. Will that at all be influenced by the third restatement on restitution? We're waiting, but we're not holding our breath. Quasi-contract flourishes in commercial law. Mistaken payments there happen all the time. Is there a quasi-contract in public law? If, for example, the German Constitutional Court finds something unconstitutional today, has it been unconstitutional always? Does that have retroactivity? And if it does, do we owe restitutions and reparations? Nice question. I'm not going to talk about that. I don't know the answer. And then, of course, I come from a mixed jurisdiction here in Louisiana. You have other mixed jurisdictions around the world. I'd be very interested to talk to you about my jurisdiction, but I don't think there's enough time in the day or in the week to do that. So I'll leave that for another day. And with that, I thank you so very much for your attention.
Thank you very much, dear Professor, for that brilliant lecture. And I have to admit, I was particularly intrigued by the solar system with the different elements orbiting around the unjust enrichment. Thank you very much. Dear ladies and gentlemen, I'd rather not be the first one to go with questions, although I would have one. So are there any questions from your side to our dear Professor Zabrados? You are, of course, many of you are coming from different jurisdictions indeed, and affected by the ones which the professor depicted to us. So yeah, please feel free to issue your questions or comments.
Well, in their defense, it's a very boring and technical topic, but at least I hope that the comparison was interesting.
The topic, yes, but you made it very, very interesting.
Let's go with your questions first, Dimitri. What would you like to notice?
Thank you very much. So you mentioned the Rome II regulation, and I'm of course familiar with the fact that the European Court of Justice every once in a while has tried to, well, add a few things, talking generally about maybe some common European principles and stuff. So, of course, within the Rome II regulation, we were finding ourselves in the international private law area. But the so-called hot potato, as we would denominate it in Greece, would be, is there any possibility, or do you see any possibility for the future? Of course, our British friends left the common European Union project, maybe temporarily, we'll see. So do you think that there are possibilities in future? Of course, the whole matter of the draft common frame of reference, for instance, some sort of try towards such a direction. Do you think that in future there can be a possibility, even based on the not few similarities between the the systems and models you depicted. Could there be a common denominator for European Union civil code, and more concrete also for matters, for those dogmatic matters regarding, for instance, the unjust enrichment? Do you think?
That's a great question, a very difficult question. So where Rome II comes into play, the European Court of Justice always reminds us that the terms used there are autonomous. When I talk about unjust enrichment, it's an autonomous term. Well, what does that mean, right? I mean, we have to refer to the jurisdictions all over to determine that. I know that Professor von Bahr made an effort for the common frame of reference and to unify everything. I think that a soft law approach would be good, because if we really look to the details, if I give you 5 hypotheticals of unjust enrichment, I think we will reach the same result, whether we're coming to it from France or from Germany. We'll just be using different terminologies, different rules maybe, but the result might be the same. And I dare say, even for our friends from the common law, and even though our British friends have left, our friends in Cyprus are still there, and they're going to be there. And so that's another common law jurisdiction to consider. And so if you're practical and result-oriented, and you can come up with the common frame of reference, just like the von Bahr one, I'm not a fan of a European civil code. I like diversity. I think that referring to general principles of law would work. That's my optimistic take on it. Now, for conflict of laws, it's much simpler because you can use broader terms. You can use unjust enrichment for characterization purposes, for calification purposes, in a broader term. And so unjust enrichment would fit a lot of concepts under there. So I guess my answer to your question is, I don't know.
Thank you very much. Dear ladies and gentlemen, as I said, there is a question in our chat. Maria asks, let me ask in chat because I'm not able, mic issues. Do you think we really need to talk about what are the names of the type of unusual obligations we talked about today? Does it matter for practice?
That's a wonderful question. We like to categorize, especially if we come from civil law backgrounds. We like to categorize, we like to use these names. The answer is no. They have no practical value. If we were starting today, we would simply say various miscellaneous. But here's the problem. Judges, lawyers, especially older judges and lawyers, books that have been written, use this obscure terminology. And so at least we have to understand what it means going forward. But yes, I agree, there's no practical value in the name quasi-contract, right? The only practical value it really has, it's a very loose category of obligations that are neither contractual nor tort. If you want a catchy name, because what could be another name? Juridical facts that are licit? Is that a catchy name? Or maybe various legal obligations, right? I mean, in Germany and in Greece, we definitely don't use a name for the category. In France, they do, but I think they understand that it's more of a descriptive term. So to answer the great question, there is no immediate practical value. It's just out of convenience that we could use it.
Thank you very much. Dear ladies and gentlemen, anyone else following Maria's courageous example here? I guess they are overwhelmed.
Or bored to death.
No. I have to admit, when I was a student, that very topic was always, to put it politely, a difficult one.
It's to follow up on Maria's question, it's unnecessarily difficult.
So for the first time today, I feel that, that's something one should hear about.
It's unnecessarily difficult, and I thank you for indulging me, everyone. Thank you so very much.
Well, dear ladies and gentlemen, if there are no further questions, and that would be your last opportunity, it's a golden opportunity to ask questions in that area. So, well, if there are no further questions, I'd like to thank our dear Professor Stavrados very much for being here with us today and for delivering this brilliant lecture. Dear Professor, once again, heartfelt thank you. And well, dear ladies and gentlemen, we're going to meet each other again. Our next edition is going to be in June now. So hopefully until then you will stay healthy and in good mood and take good care of yourselves. So thank you warmly and bye-bye.
Good night, everyone. Thank you.